Morning. I'm going to discuss whether Rosa may have a tortious claim against any of the defendants. First, I will discuss how Rosa's employers, namely the Tate Gallery and the various churches she volunteered for, failed to provide any safety equipment while using chemicals, and this may constitute a tort negligence. First, we have to establish whether there was actionable damage. Contracting lung cancer from the use of these chemicals does constitute actionable damage, and this is from Rothwell v. Chemical. Second, we need to establish a duty of care. Typically, in English common law, an employer to employee relationship has a duty of care as per Wilson v. English. As there was a pre tort relationship, this gives rise to a positive obligation where inaction would constitute a breach of duty. It isn't as clear cut for the churches as there is no established case law between a volunteer and an employer in duty of care. However, we can use the approach established in Robinson, which allows the courts to establish a new duty of care when there's factual similarities between existing duty of care. So I would argue that an employee and a volunteer are very similar. The only real difference is monetary compensation. So I believe a duty of care should be extended to a volunteer in the situations, thus maintaining the claim against the churches. Next, we have to establish whether there was a breach of this duty, and this is typically done by an objective standard test known as a reasonable person. Here, Rosa should argue that a reasonable employer would have supplied employees with protective gear while using chemicals on the job, and by failing to do so, both the churches and Tate Gallery have breached their duty of care. However, the reasonable employer here needs to take many things into consideration, one of which is the probability of injury. The defendant will not be negligent if the probability of the injury is significantly low. This may hurt Rosa's claim because it's not conclusive to say whether the injury was high or low, but it was just increased by the chances of using Artium. Second, we need to discuss whether there was the seriousness of the injury. The seriousness of the injury needs to be taken into account when assessing the precautions a reasonable employer should take to ensure the safety of their workforce. This is from Paris v. Stepney Council. And considering that lung cancer is very serious and deadly, the defendant will be more likely to fall below a required standard of care. And even if it's not normal practice to provide employers with safety equipment while using Artium, the damage was so severe that there should have been protections in place, thus constituting negligence. Next, we have to take into consideration the cost of taking precautions, whether economic or otherwise. This is from Latimer versus AEC. And here, Rosa can argue that the defendant did not take reasonable precautions to minimize the risks to employees, as there were simpler alternatives such as other solvents or providing safety equipment such as a painter's mask, which can go for around £15 on Amazon. Lastly, we have to discuss the social utility of the activity. The courts are more likely to find it reasonable to have dispensed with safety precautions if there's high social utility, but this is typically reserved for cases involving emergencies, as per Watt v. Hertfordshire. However, the maintaining of paintings is not really an emergency or heat-of-the-moment activity, therefore the social utility argument does not apply. Taking all these things into consideration, a reasonable employer would have provided Rosa with safety equipment as she was using chemicals that was not aware whether they could cause harm long term. Therefore, their employers, both Tate and the churches, breached their duty of care. Next, we have to establish causation. This is typically done with a but-for test, but because we cannot conclusively say when Rosa's damage was caused, Tate's negligence, or whether Tate's negligence caused this, Rosa fails the but-for test. However, there are situations where the but-for test is not used and which can be abandoned by the courts, and fortunately one of which applies for Rosa's case. As seen in Fairchild, there are sometimes in situations of fairness and justice the but-for test could be departed from because it creates an unfair and unjust result. This is the case here because we cannot pinpoint conclusively when the damage was occurred by Rosa, but we know that the damage occurred because of negligence based off the church or the Tate Gallery. So here the church or the courts can override the but-for test. This is known as the Fairchild principle, which applies in situations where there are multiple defendants causing indivisible harm. This principle applies and the claim can move forward despite abandoning the but-for test. However, it is worth noting that in Barker v. Corus, it is established that in these instances, it is proportional liability. So the damages will be proportional for the amount of exposure caused by the defendant. As the numbers are not conclusive, it will be impossible to determine that 100% of the damages was caused by a certain negligent defendant. Therefore, Rosa will not be able to get 100% of damages. It is also worth noting that the Compensation Act 2006 does not apply here because that act strictly refers to asbestos-caused cancers, and Rosa's cancer is not caused by asbestos. Therefore, again, does not apply. Next, we have to establish legal causation after we've done a factual link between the defendant's breach of duty and the claimant's harm. However, this is based off of two principles, the first of which is remoteness. The defense will argue that the exact type of harm was not reasonably foreseeable as it was only known by the medical community and the common practice of RDM was common in the industry. They will argue that the exact type of harm was so far-fetched that no reasonable employer would be able to predict this, and this is established in the case of Wagon Mound. However, Rosa can argue that a reasonable defendant would be able to foresee some type of harm from constant exposure to chemicals without protective equipment, and the type of harm was not too remote because it was foreseeable. This is following Hughes v. Lord Advocate. And just because the harm was severe doesn't mean that a type of harm was foreseeable. A reasonable employer should be able to foresee that the constant exposure to a chemical may have long-term health effects. Next, we have to establish whether there was an intervening act. In the case of Robinson v. Post Office, a medical professional's negligent act does not break the chain of causation, therefore con does not matter in this situation. Next, we're going to discuss acts of claimant. Here, the defense may argue that Rose's personal usage of the chemical may constitute an intervening act, but we cannot conclusively say whether Rose's personal usage broke the chain of causation, therefore this argument will not apply. Lastly, there's going to be some defenses that are going to be raised by the defense, such as contributory negligence, which is from the Law Reform Contributory Negligence Act, 1945. And there must be a direct causative link between the claimant's actions and the injuries on the case, but this is not the case as we cannot confirm there is a direct causative link. Second, the notion of volunteering. The churches may argue that Rose's volunteering to use RDM on the paintings means she consented to the negligence. However, she was not fully aware of the side effects of the chemical, therefore this argument will not apply. Next, we have to discuss tort of negligence involving the breathing specialist, Mr. Kahn. Again, actionable damage exists in the lung cancer. As for a duty of care, it exists from Kent v. Griffiths, and it held that existence of duty of care exists between someone undertaking the care and treatment of a patient, which Dr. Kahn has done. Next, to establish a duty of care, we depart from the reasonable person's test because he is a professional in a certain field. I would argue that Kahn is a professional because he has two abilities that normal individuals do not. First, the ability to diagnose specific breathing problems, such as asthma, and second, the ability to prescribe medication to patients. This is very similar to a doctor in established professional practice, therefore I think this will apply, and the defense will argue this approach because a professional practice has a higher standard of care than a reasonable person. This then puts Mr. Kahn up to the Bolam test. And to prove this, the claimant must establish that act as a reasonable person in the position, and therefore Rosa has to show that Kahn did not act like a reasonable breathing specialist in this situation. We can easily do this by pointing to this second breathing specialist that was easily able to diagnose Rosa in first instance. Kahn had over 2 years to correctly diagnose Rosa, but he failed to do so. Therefore, we are able to show that Kahn was not acting like a reasonable breathing specialist, as a reasonable breathing specialist was able to diagnose Rosa correctly. The claim is able to continue. Next, we have to go to factual causation. Again, we have to use the but-for test, and here the onus is on the claimant to prove on the balance of probabilities that the defendant's negligence led to the harm suffered. Because the doctor's negligence was not conclusively necessary to the patient's harm, considering that Rosa's prognosis was poor to begin with, the defense will argue that they are unable to prove for fact that Kahn's negligence increased her likelihood of death. This follows the case of Barnett versus Chelsea in Kensington Hospital, where the court is satisfied that even if a negligent doctor had acted properly, the claimant would have succumbed to the illness. They will follow this precedent and argue that Rosa would have likely succumbed to the illness anyways, and then this fails the but-for test, potentially hurting the claim against Dr. Kahn. Lastly, we should note that a loss of chance argument does not matter here. Policy speaking, it is difficult to win claims based off loss of chances, so the court would be unlikely to award in Rosa's favor. And this is established in Gregg v. Scott. Therefore, the claim against Kahn fails, and it will not succeed. In conclusion, I believe there's a successful claim against the Tate Gallery, but there's a chance the defense may prevail, depending on the arguments of causation, specifically remoteness. Considering Rosa can only bring one action for one type of harm, Rosa should bring this claim against the Tate Gallery. Second, I believe that Rosa's claim against Kahn will fail at the stage of factual causation, therefore it is not worth pursuing. Thank you.